In Florida, in order to get a divorce, you have to allege that the marriage is irretrievably broken. It doesn't take both parties to agree to that, only technically one. And then also too, there is the ability, if your partner is incapacitated, you are eligible to get a divorce, but you must wait a period of 3 years. In order for a marriage to be irretrievably broken, essentially, all that means is that one of you wants out. You don't really have to give a real reason. Florida doesn't really care. You just have to allege that it's broken. So in Florida, assets are divided by what is called equitable distribution, which means that you start at a presumption that each party is entitled to 50% of the assets or the liabilities. In Florida, it does not matter what the asset or liability is titled in, or if the debt is in one party's name. All that matters is that it was accrued during the marriage. If it was accrued during the marriage, then each party is equally entitled to or equally responsible for that asset or liability. In Florida, alimony is also what is known as spousal support. So there are multiple different kinds of alimony in Florida. Those include bridge the gap alimony, rehabilitative alimony, durational alimony, lump sum alimony, and then in some cases you may be entitled to temporary alimony while your case is pending. Alimony in Florida, whether or not that is going to be awarded, there are a couple different factors. One would be what we refer to as need versus ability to pay. So as a part of the process with divorce, you will be required to fill out a financial affidavit. Both parties are required to do this. This document lists out what your income is, what your monthly expenses are. Do you have a surplus or do you have a deficit at the end of the month? If you do have a surplus, then that means that you're probably not entitled to alimony. However, if you have a deficit every month, that shows the court that you have a need, which means that you meet that burden as to whether or not you can pursue alimony. On the flip side of that, if you are seeking alimony, you got to show that the other side has the ability to pay. So we have to show that they have a surplus. I wouldn't say that it's difficult to obtain alimony in Florida. It just kind of depends on your case and the specific financial factors for your situation. In Florida, everybody hears the term custody. However, in Florida, that's actually not a term that's recognized. The way that I explain it to my clients is that there's technically two parts to custody. There's what we call parental responsibility, and then also time sharing. Time sharing is essentially how many overnights, your actual visitation that you have with your child or children. And then parental responsibility refers to your rights as a parent to make decisions in the upbringing or caretaking of your child. For parental responsibility, there are two different kinds. There's either shared parental responsibility or sole parental responsibility. In Florida, it's pretty much a guarantee that you're going to get shared parental responsibility, which just means that each party has the right to make decisions and that you have to consent the other party before you make any decisions related to your child's education or medical treatment, things of that nature. In order to seek sole parental responsibility, you have to show that having the other party involved in the decision-making process for your child would be detrimental to your child. So in order to be able to prove that, it's a pretty high standard. Some examples of what would meet that burden would be substance abuse or domestic violence, those sorts of things. If you have that, you have the ability to ask the court for sole parental responsibility. If that's not really the situation, then 9 times out of 10, you're probably going to end up with shared parental responsibility. If you have any questions related to divorce, custody, alimony, or anything that involves the divorce process, we'd be happy to discuss that with you at a free consultation at Cooper & Cooper, PA.